សូមអញ្ជើញអស់លោកស្រីអង្គុយចុះ
The President, please be seated.
អង្គជំនុំជម្រះប្រកាសបន្ត
The court is now back in session. Before we proceed this afternoon session, the Chamber would like to notify the accused and their counsels that according to the internal rule 81(3), 4 and 5, the accused presence is required during the proceedings, the trial proceedings. The accused shall be present in this courtroom. With regard to the other provisions in Rule 81(3), 4, 5, it depends on the state of the health of the accused who for that reason cannot be attending the trial proceedings, and for that reason there must be reasoning to be submitted to the trial chamber for consideration. And the trial chamber would like to also inform that each and every day of the court proceedings, the accused person shall be present before the chamber preliminarily, before presenting other reasons that lead to the request for withdrawal from the courtroom or retired from the courtroom to the holding cells or to the detention facility and observing the proceeding through remote participation. The AV equipment have been installed so that the accused can also observe the proceeding through remote participation. From now on, we would like all parties to abide by this provision. And the chamber will reserve its discretion to grant permission to the accused persons whether he or she shall be allowed to observe to be absent from the courtroom or not. And as I already indicated, holding cells have been well equipped with the AV equipments, and that the accused person who would wish to go and stay in the cells can observe the proceeding unless his or her health condition needs him or her to be taken back to the detention facility. Counsel Sorsawan, we note your wishes to make some observation. Counsel Sorsawan, thank you, Mr. President. We have been very well informed and will take this very seriously. However, during this time of the hearing, my client has been rather tired and fatigued, and he would like to ask for the chamber permission to allow him to go to the holding cell downstairs, and that he will be coming back to the courtroom tomorrow. He says it would be okay now, for I will be representing him in this courtroom, and that the court proceedings today are dedicated to other defense counsel rather than to him in particular. So he would like to reserve his energy for tomorrow's session instead.
But
The President. The Chamber has noted the request by Counsel Saw Sowan and of course noted the reasoning behind this request. The Chamber notes also that the situation or the health condition of the accused, Mr. Khew Samphan, does not appear to be deteriorating or severe. That's why the Chamber finds that he shall remain seated in this courtroom.
If I may be heard, Mr. President, concerning my client and concerning the remarks made by the trial chamber concerning this matter, which I think it's a rather serious matter. And let me begin by first describing how things are happening at the ICTY, since the prosecution in particular seems to enjoy pointing out how things are at the ICTY and how this trial chamber should look to them as for guidance. I'll also touch upon a little bit on some of the international principles. First and foremost, Mr. President, with the deepest respect, I believe that when an accused feels that he is not able to be in court and is willing to waive his rights to be present, that those wishes have to be granted by the trial chamber. At the ICTY, nobody's forced to come to court. No one. They don't even have a holding cell for the individuals to watch the proceedings. They have made provisions in their cells at the detention center to participate or to watch the proceedings should any of the accused feel unable or simply unwilling to attend the trial, their particular trial. And when an accused waives his presence or her presence, that accused cannot later on say that they were not afforded their due process rights because that was a personal waiver made by the accused. And in the trial that I just finished, which lasted 5 years, several of the accused at times simply did not show up because they did not want to show up, not because they could not show up. They chose not to show up for a variety of reasons, including my own client. And this was for weeks and months at a time. I'm not saying it's a good practice or a bad practice, but I'm merely pointing it out to the trial chamber. We respectfully request that some further consideration be given to this matter because these individuals are old. They may look fine by appearances, but our client in particular has problems sitting for long periods of time. He also needs to use the restroom virtually every half hour. It is painful for him to be here. He cannot concentrate. He cannot really assist in his own defense. However, the trial chamber has adopted a procedure which I believe is on the cutting edge of the law, which is to have holding cells nearby where the clients can participate and can assist their clients. Now that our client and the others have made their initial appearance, I would respectfully suggest that the accused, if he or she were to represent to their lawyer, and if they were to sign a written waiver so that there is a document that the client actually is waiving as opposed to merely a representation by the lawyer, even though lawyers are effectively officers of the court and are duty-bound to speak the truth, we believe that the trial chamber should honor the accused's wishes not to be present. Forcing an accused to be present when they cannot or do not wish to be here is not a solution. As I've indicated, if an accused wishes not to attend for whatever the reason may be, that is a personal decision being made by the accused, and no rights are being taken away from him by the trial chamber. Conversely, forcing an accused to be in court when they're physically or even mentally not willing to, or not capable or willing to be here, I respectfully submit borderlines on a violation of an accused's fair trial rights and the human rights. Now, I understand that that is not the intention of the trial chamber, and I'm not suggesting that that is what the trial chamber is attempting to do. But I simply point out that perhaps further consideration of this issue may be warranted. And of course, I think we need to be flexible, keeping in mind that our respective clients are rather old. With respect to my particular client, for this afternoon, he was ordered to be back in court even though he had indicated to Chambers privately that he was unable to be here. He is here presently. He wishes to participate for the rest of the afternoon in the holding cell, watching the proceedings in the holding cell that was prepared for him. And so we would respectfully request that his particular request be granted. And following that, Your Honor, I have one point of clarification I wish to make concerning one of the remarks I made this morning to clarify the record.
The President, Counsel Kanawaz. I have noted your observation, and I thank you for sharing with us the experience with reference to the international tribunals in which the accused person of advanced age as those who are before this court, and that you mentioned about the rule, for example, that accused person shall not be forced to appear before the courtroom, and also you touch upon the issue concerning the participation through remote participation, for example, and you indicated finally that you would like the chamber to address some of your requests. I think through Khmer translation, we have not been fully seized of what kind of request you would like the chamber to address for this moment, because the issue for the time being is, of course, concerning the presence of the accused at the hearing, and that you indicated your client would be attending these proceedings in the afternoon session, but at the same time you requested that the chamber address some of your requests. But what requests are certainly?
I apologize, Mr. President, for not being clear in stating my points. For this afternoon proceedings, our first request is that Mr. Ingsuri be excused from being in court and that he participate for the remainder of the afternoon in the holding cell that has been prepared for him. That's our first request. The previous request that I had made is for the trial chamber to reconsider its position, the remarks given by you, Mr. President, earlier, where you indicated effectively, and I might have misunderstood because something may have been lost in translation, that even where an accused is unable to come to court or is unwilling to come to court, the trial chamber would force the accused to be in court. Effectively, that's what my understanding of it was. And if I may use an example, when the attorney for Mr. Kyu Sampon indicated that Mr. Kyu Sampon wishes to be excused, that request was denied. So effectively, Mr. Kyu Sampon is being forced to attend a proceeding where he either is unable to or is unwilling to attend. And I'm not going to speculate, but the remarks were that he's unable to, in addition to the fact that these matters do not touch upon him at this point in time. So based on that, as an example, Your Honor, what I am requesting that subsequent to the proceedings today, that perhaps Your Honors can more fully discuss this matter amongst yourselves and consider the ramifications. The alternative is to allow the parties to brief the issue. Although I think writing more on this particular issue at this point in time of the proceedings may not be beneficial or a beneficial way of spending our time. But I do believe that if a client does not want to be in court, he cannot be forced to be in court. And if he's unable to be in court, he should not be forced to be in court. And I do believe, my personal opinion, and I can do more research on it, but I believe that forcing an accused to be in court when the accused is waiving his or her presence, recognizing the court or even not recognizing the court, once they waive their presence, it is a voluntary waiver. Their rights are not being violated, but I think it is a violation of human rights to force an accused to be in court when he or she is clearly unable to be here. Now, I hope I got my my requests. I hope that they're clear at this point in time. So for right now, Mr. Ingsuri be excused for at some point after the hearings for Your Honors to reconsider. And I point this out because I've noted, and I don't wish to make a point of this, but when Your Honors gathered together to discuss it, not all judges were participating in that discussion. Now, I assume that this discussion took place prior to coming to the bench, and that's why there was no need. But I think this is a very fundamental issue. This is an extremely important issue, and I think we're being judged how we're going to proceed with these proceedings. I clearly want to state on the record that our client wishes to participate in this tribunal. But when he cannot, he will inform his lawyers, we will inform you, and I think that's the better approach. But I'm simply seeking you to reconsider your position based on the arguments and any arguments you may find amongst yourselves. Thank you.
The President, International Co-Prosecutor, you may now proceed.
Thank you, Mr. President, and I'll be quite brief in responding to my learned friend's comments. There is, of course, in any legal proceeding, a basic requirement that an accused attend those proceedings. And whereas Mr. Karnavas gives examples from the Yugoslav War Crimes Tribunal of individuals not attending trial, and there are some examples of that, the vast majority of individuals...
Counsel Angadam interrupts. Our sincere apology. Actually, my colleague has two requests and both of them have not been addressed. May I also reiterate that my client be accused and that he remain in the holding cell observing the proceeding, please. The President, the International Co-Prosecutor, you may now continue.
Thank you, Mr. President. As I said, there is a basic fundamental requirement that an accused attend trial. There are some exceptional examples at the Yugoslav War Crimes Tribunal where individuals either could not attend through illness or refused to attend. Now, I think first and foremost, in terms of any of these accused being unable to attend through infirmity or physical or mental condition, the court actually needs to have expert evidence on that issue and not just evidence from Mr. Karnavas about the state of his client. Now, in terms of an accused actually not being present in the courtroom during the proceedings, if the court were to grant that application, it needs to be very clear why the individual is not attending. Is the individual not attending because they don't want to be here, like Mr. Nuanchia this morning, or is the individual not able to attend because of physical or mental infirmity? And I think for the sake of the record of these proceedings, and in order to ensure that there aren't later complaints by the accused that they haven't actually been able to participate in their own proceedings, that every time that they are excused from the court for whatever reason, the reason is actually recorded in writing, and as Mr. Karnavas says, they expressly waive their right to be here. I think it's absolutely essential that that record is kept, because otherwise what we will find is later on in these proceedings, accused make complaint, even though it was their own choice that they weren't attending, that they haven't been able to participate in the proceedings. But fundamentally, I would remind the court that in all jurisdictions, and certainly in my own jurisdiction in England and certainly in the international jurisdictions, accused are expected to attend their proceedings. Thank you, Mr. President.
Just very briefly, Mr. President, there may be this expectation.
The President, could you please stop here? The Chamber will, of course, consider your observations. We have already noted the reference to the international tribunals, and you also indicated that you would conduct further research to this to help expedite the proceedings. We can reiterate that we have taken note of your observations and that we are not now in the position to rule on this yet. We will deliberate on this to see what kind of approach shall be conducted pursuant to both national and international standards. So we would like to end this debate on this issue now.
Thank you, Mr. President. May we then get a decision on our first request, and that is for Mr. Ieng Sary at this point in time to be excused, or is he going to be forced to sit here for the rest of the afternoon without some kind of medical examination, as Mr. Cayley is suggesting? Or may he be excused at this point in time?
Resume your seat until the judges have had an opportunity to discuss these matters, please. Please do us that courtesy.
My apologies.
The President. May the Chamber emphasize or seek clarification with regard to the requests made by Counsel for Ieng Sary, so that the bench can have it as the foundation for our consideration. Counsel Ang Odam. Thank you, Mr. President. This morning there were two cases. Mrs. Ieng Thirit and Nuon Chea requested to be excused, and when the requests were made, then the chamber ruled on immediately. My client, Mr. Ieng Sary, has three key elements. In particular, he has severe back pain. That's why we have requested that the chamber allow him to be excused and observe the proceeding in the holding cell. The President, judges of the bench are now allowed to actually make comment concerning this, because so far as we have observed that the request in the request itself there is conjunction or.
Alors, peut-être pour essayer de clarifier un petit peu les choses.
In an attempt to clarify matters, the Chamber wishes to draw the attention of parties on the fact that the internal rules provides for two situations, two different situations. The first is this. It is set out in Internal Rule 91.3. In the event, or 81.3, in the event that the accused refuses to appear, in such a scenario, he can waive his right to be here and allow his counsel to make representations, but make the deliberate choice to not appear. But in order to make things perfectly clear and transparent to the Chamber, wishes to know at the beginning of each hearing day, the Chamber wishes to know if each accused person intends to appear before the Chamber or not. Is that clear? The second scenario is set out in paragraph 4, where the accused may not refuse to appear but may participate remotely. Now, in the event that the accused does appear remotely, it is only when the accused has made known that he or she suffers from health problems or any other serious matter. In order for the Chamber to make a determination, the Chamber must know what those health reasons are or what those serious reasons are, in order to understand the basis for wanting to participate in the proceedings remotely. Now, for the two accused persons who are present this afternoon, the Chamber considers that there's a difference between the situation of the accused person, Kyo Sampan, and the accused person, Yang Sari. Mr. Sari's counsel has pointed out that their client suffers from health problems.
N'est informé.
To this date, the Chamber is unaware of any medical reasons. And in fact, the Chamber believes that he has refused medical examination. Now, in order to clarify the situation, the Chamber wishes to draw the attention of all parties on the differences between paragraph 3 and 4 of the specific rule within the internal rules.
Pardon, 4 et 5.
I beg your pardon, those are paragraphs 4 and 5.
Thank you, Judge Laverne. If I may respond briefly, and first I wish to say that when I was standing, I was not trying to be discourteous to the court. It's from where in my jurisdiction, I'm expected to stand until given permission to sit down once I'm on my feet and the court is addressing me. So I apologize if it appeared that I was being discourteous. To my understanding, my client has never refused medical treatment and has never refused to be examined. That came out in the translation. It might have. Now, there's a third scenario, Your Honors, where, for instance, the accused wishes to be present, refuses to waive their presence because they're not medically fit. That's not the situation that we're faced here today. In other words, he's not going off to the hospital, but still wishes to be here, and therefore the proceedings should not go forward. Our client, and there are medical records that are available to the trial chamber, suffers from a variety of illnesses. He's 85, 86 years old. I don't need a medical doctor to tell me that Mr. Inksheri has a problem concentrating or sitting because I've met with him for the last 3 years. Granted, my word should not be sufficient. I indicated, and this was brought out by the prosecution, perhaps more clearly, that on each occasion, and that's what I meant, on each occasion, that is every day that someone is not here, whether it's a morning session, afternoon session, there needs to be a written record, something signed by the accused, that they're voluntarily waiving their presence. I do not agree with forcing an accused to be in court if they're physically incapable of being here. I also personally do not agree, and I think it is a violation of an accused's rights, to force them to be in court when they don't wish to be here. That's a personal choice. With respect to Mr. Inksheri, this afternoon he's suffering. He was forced to come up. He is suffering right now. We've made this request. We were very clear. He wishes to participate for the rest of the afternoon downstairs in the holding cell. The United Nations spend lots of money preparing those cells for these eventualities. This is one of those occasions when it's going to be put to good use. Now, tomorrow morning, if Mr. Inksheri is in fact unable to come, he will communicate that to us. Perhaps he can be examined as well. We will notify the chamber, and we're prepared to have him sign a waiver indicating exactly the reasoning why he does not wish to be here or cannot be here, so that there is a record. So later on appeal, there can be no challenges that he was not present and was not able to have a fair trial. And I think that solves the situation.
Oui, Monsieur le Président.
Mr. President, very briefly. Civil party lawyers will defer to the chamber in order to put weight on the representations made by the counsel for the defense, for the accused rather. We simply want to recall that to the extent that it is possible, and to the extent that all of the rights are respected, this is a matter of respect for victims and civil parties. And some of these civil parties are also of an advanced age, and they have deployed significant effort to be here. And to participate in these proceedings is something quite tremendous. And if possible, they would like to see the accused present during these proceedings.
ក្រោយពីបានស្ដាប់
The President, having observed the request made by counsel for Ieng Sary and also the response by the co-prosecutor and lead co-lawyer, and having discussed on the request, the chamber has found that the accused person has reason for us to believe that his health condition is warranted for permission to remain seated or at the holding cell, and that he observes the proceeding through remote participation with AV equipment installed in the cell. The chamber would like to reiterate that all accused persons shall be brought to the courtroom early in the morning of every session. And the chamber will look into the request on a daily basis, on a case-by-case situation. For example, if such a request is made concerning the presence of the accused in the courtroom, and whether the chamber would grant permission or not. The detention facility security personnel are now instructed to bring the accused person, Mr. Ieng Sary, to the holding cell, and that he will be observing the proceedings through AV installed equipment. The President, next the chamber would like to proceed to the floor for the co-prosecutor to respond to the observation made by counsels for Ieng Sary this morning with regard to the preliminary objections on the nebis in idem. And the chamber would like to also note that this morning the co-prosecutor submitted a request before the chamber with in which he indicates that he would like to address or respond to the observation made by defense counsel for Ieng Sary. The co-prosecutor has requested the chamber to grant the prosecution some time to respond to that observation. And the chamber has agreed to the prosecutor to respond for 5 minutes. Please hold on, or you may proceed.
Just a point of clarification to my argument this morning, because I might not have been clear on one point. When I indicated during my remarks that the appeals chamber, and I had quoted, had noted concerning Article 12 of the Cambodian procedure, criminal procedure, where it said that Article 12 of the CPC is set out above at paragraph 45, may be regarded as an example of the application of the doctrine of res judicata. That quote was from an earlier decision, Your Honors, not from the closing order or the appeals to the closing order. It was from their decision dated 17 October 2008. It's found in paragraph 47 of document C22/1/73. I just wish to clarify that point so there's no misunderstanding as to where that quote comes from. That's in 17 October 2008.
លោកមេធាវីជប់
The President Council Kanawaz, could you please hold on? How much time is needed for you to do that? Because I observe that the allocated time for the Defense Council has already been used up, and that we already made it clear that councils is not allowed to make repeated the same observation, and that the chamber also advised the parties to really write in a written submission if they would wish to really add further observation on top of the allocated time. We just would like to know how much time would you need to address this matter before us so that we are decisive on this. We made it clear, as I indicated, that 1 hour has been allocated for your council and for your team, and that it has already been used.
Mr. President, again to clarify, I don't know how things are happening in translation, but perhaps I'm speaking too fast. It is not further observations. This morning when I was discussing the interplay between Article 7 and Article 12, I may have given the wrong impression when I quoted from what the pretrial chamber had found. The quote where I indicated that the pretrial chamber had suggested or had found that Article 12 should be regarded as an example of the application of the doctrine of res judicata. That is found in their provisional detention order of 17 October 2008. It is not in the closing order or the appeals to the closing order. And so I wanted to make sure that I clarified that point for everyone's convenience. And that's found in paragraph 47 of that decision, of that order. So that's the only point I wanted to clarify, because it appeared from my colleagues that I might have given the wrong impression. That's all, Your Honors. I apologize if I'm testing the trial chamber's patience.
អញ្ជើញសហប្រញ្ញា
The President, the International Co-Prosecutor, you may proceed.
Thank you, Mr. President. Actually, just one point of clarification for Mr. Karnavas, and it's quite right, he was actually clarifying things this morning. He said appeals chamber in his first set of submissions, and I think he meant the pretrial chamber. So it was a decision of the pretrial chamber and not the appeals chamber. Yes, Mr. President, thank you. I need 5 minutes to address the submission made this morning by Defence Counsel for Nguyen Chia. A number of points I think need to be made to really clarify matters for the public. I think that the trial chamber is aware of many of the facts that I'm going to state, but nevertheless I think for the purposes of the people who are watching in the world at large, a number of points need to be made. First, Defence Counsel for Nguyen Chia essentially stated that their client had been subjected to a secret investigation. This is not correct. Whilst the investigation is not public, the Nguyen Chia team have been aware of every step taken in that investigation over the 4 years in which they have been instructed in this case. The witnesses, the statements and the documents on which this trial has been based have all been accessible by the defence team for Nguyen Chia. The fact that it's been confidential to the public during that time period is a requirement of investigations within the legal system of the ECCC. But of course now that evidence will become public and will be scrutinised not just by this trial chamber, but by the public at large during the course of this trial. So to suggest that Nguyen Chia has been subjected to a secret investigation is very misleading indeed. Secondly, Defence Counsel for Nguyen Chia stated that his client's 26 investigative requests had been ignored by the investigating judges. This is not correct. A number of the requests that they have made have been accepted in full or in part by the co-investigating judges, and a number have been rejected, and that has happened to all of the parties to these proceedings, and a number of those investigative requests that have been rejected have been appealed. The defence are aware also that they have opportunity within these proceedings to request that the trial chamber investigate matters further under Rule 93, which they've done so, and to which we, the Office of the Co-Prosecutors, have responded. Indeed, we're awaiting your decision on that matter. The prosecution's position on this issue is very clear. We believe that this trial must be fair, it must be expeditious, but we will always support any request from any party where it has the potential for producing relevant evidence as to determination of the innocence or guilt of the accused, and for that matter, anything that would mitigate their criminal liability. However, it must be said that not every investigative request that is made by a party may be crucial to determining the principal issues in this case. Also, some requests may become more or less relevant as the proceedings progress. But to suggest that there has been a blanket refusal of all investigative requests that Nguyen Chia has made is simply not right. Counsel for Nguyen Chia stated this morning that there were over 300 witnesses that they had requested that have not been taken into account. It must be remembered that on their initial witness list they actually had 527 witnesses, of whom, certainly in the prosecutor's view, a very small proportion offered any evidence that was relevant to the crimes or the role of the accused in this particular case. The defence have put forward hundreds of witnesses that testify to the general conditions, the role of the United States in the pre-democratic Kampuchea period, the general state of affairs during the democratic Kampuchea period, but provided little information as to the description of the evidence they intend to offer or what that evidence actually does to assist the judges in determining matters in the closing order. The Nguyen Chia defence have not objected to the approximately 300 witnesses that the prosecution originally put forward as required under the rules 4 months ago. This means, at least to us, that they agree with the presentation of this evidence, i.e. that it will provide relevant and probative evidence, and that they will be given the opportunity to question those witnesses on the context that they think is relevant to this case. We would also say that I think at this stage the statements that they've made are rather premature, bearing in mind that the Chamber has already stated that the issue of the witness list will be discussed on Thursday, and all of the parties will have the opportunity to make representations. On the fair trial issues that they raised, the fair trial issues that have been raised by the Nguyen Chia defence team have been the subject of extensive public written litigation. To suggest somehow that their complaints have been ignored, again, is unfair and misrepresents the reality of the situation to the general public. This is a matter that we have responded to. It is under judicial consideration as we speak, and the public need to know that fact. Lastly, we would reiterate, and we say this most respectfully, because we recognise the responsibility that the trial chamber has. You have a responsibility to manage this trial. all of the issues that the defence raises are issues that you need to properly determine. Walking out of trial on the first day of a trial simply shows an intention not to participate. Now, that is his choice. He can do that if he wishes. He must, as we've previously discussed when Mr. Carnavas raised the issue, he must sign a written waiver stating that he doesn't want to participate in the proceedings. But let us be absolutely clear that many of the reasons that the Defence Counsel have given for their client walking out this morning and which have been received by the public are simply not true. Now, I don't have anything further to say on the matter other than that I think all of the parties, because of the public interest in this case, are obliged to represent things properly before the trial chamber so that ideas don't develop outside this courtroom that may be destructive to the processes that are going on here. Thank you very much indeed, Mr. President, for the time that you've given me.
The President, thank you, Mr. Co-Prosecutor. Next, we proceed to the response to the preliminary objection concerning nibis in idem. Raised this morning by defense counsels for Ieng Sary. Mrs. Chia Liang. Thank you, Mr. President, Your Honors. I am responding to the preliminary objection concerning the bis in idem. Your Honors, this initial hearing, the counsel for Ieng Sary raised the issue concerning the violation of Ieng Sary when the nibis in idem principle is introduced at this court. They indicated that Ieng Sary was already tried by a court in 1979, the 15th of August, and that the judgment of that court bars Ieng Sary from any further prosecution, and that if it is applied, it were applied, then Ieng Sary would be sentenced for the same twice. Before I proceed to this argument, this observation, I would like to draw your honors and the party attention to the principle of res judicata as indicated by Ieng Sary's defense team, that this kind of principle has been indicated or set forth in Article 12 of the Code of Criminal Procedure of Cambodia, which states very clearly that a trial of the same fact cannot or act cannot be brought again or conducted again on the same accused person. And in light of that, with regard to the facts before this chamber, we found out that the defense is erroneous when making such observation. Because the situation back then or in the provision is more about when the accused person has been acquitted, not convicted. For that reason, there is no, he is not barred from being prosecuted again. From this, my colleague, Mr. Andrew Kelly, will also be elaborating further on the nibis in idem, and that the trials in 1979 were not conducted according to the international standard and fair trial standard. He also will be touching upon the with reference to the international covenants on civil and political rights concerning the principle of nebis in idem. Mr. Ieng Sary was sentenced to death by the People Revolutionary Court in Phnom Penh for his crimes committed during the period of 3 years, 8 months and 20 days. The court trials proceedings were conducted on the 15th of August 1979 and ended on the 19th of August 1979. And the court was established in accordance with the decree law dated on the 15th of July 1979 for the prosecution of genocide committed by senior Khmer Rouge leaders, including Pol Pot and Ieng Sary. The court sentenced Pol Pot and Ieng Sary to death, and all their property was ordered to be confiscated. In the judgment of the People Revolutionary Court, stated in particular facts with relation to the crimes committed under Democratic Cambodia, and there was only one offense, which is the genocide. However, if we look at the case file 002 as dated on 19th of September 2007, the current case before us, there are several facts against the accused person Ieng Sary, including crimes against humanity, grave breaches of Geneva Convention of the 12th of August 1949, genocide, and crimes as set forth under Penal Code of 1956, all of which have already been laid down in detail in the closing order of the co-investigating judges. The People Revolutionary Court conducted the proceedings in 1979 for 5 days, and the hearing ended on the 15th of August 1979. Rather, on the 19th August 1979 at 11 a.m. People Revolutionary Court did not actually conduct a broad investigation concerning the severe crimes and the complexity of the crimes that committed all across the country, and where more than roughly 2 million people died. The court, the PRT court in Phnom Penh in 1979, was conducted or was started, and of course we understand that there was shortcoming in certain procedures, lawmaking, and the human resources. But the court itself already sentenced Pol Pot and Ieng Sary, and that the procedures at that time were legal, and they were conducted to respond to the anger of the people of Cambodia, those who survived the Khmer Rouge regime. They were suffering both mentally and physically, and that's why the court set up to prosecute the crimes committed to serve the interest for the victims as well. Your Honors, the President and parties to the proceeding, currently, if we compare these proceedings before this tribunal to the proceedings before the People Revolutionary Court in Phnom Penh in 1979, we can see that there was still shortcomings during that time, and that we also can see that Cambodia was not yet the signatory to the ICCPR at that time. We were the signatory of that covenant only on in 1992, when we was then represented by the National Supreme Council of Cambodia, the only legitimate institution. And then, of course, it was before the general election organized by the United Nations Transitional Authority in Cambodia, or known as UNTAC. Because the revolutionary People Revolutionary Court of Phnom Penh in 1979 lacked legal basis and other key procedural standards, the prosecutor would like to respond to the arguments raised concerning the nibis and idem, that the law of the ECCC and the internal rules do not really state any guidance concerning the nibis and idem with regard to the same fact. It is therefore required that the ECCC seek guidance from Criminal Procedural Code of Cambodia and international instruments. Article 12 of the Criminal Code of Procedure of 2007 states concerning the res judicata, and it states very clearly concerning the nebis and idem that shall not be applied with regard to the same offense. The Article 12 states that in applying the principle of res judicata, any person who has been finally acquitted by a court judgment cannot be prosecuted once again for the same act. For that reason, Ieng Sary shall not be barred from any further prosecution, and that Article 12 of a Criminal Code of Cambodia of 2007 shall not be applied with regard to Ieng Sary's case. The purpose of the principle of double jeopardy or nebis in idem is to protect an accused from the hardships of enduring multiple trials and punishments. However, Mr. Ieng Sary was not present at the trial, nor has he suffered any punishment. On top of this, the nebis in idem principle concerning the same fact has been mostly found on the notion that it is unfair for the accused to receive a double sentence for the same fact. So, in conclusion, the current proceedings before this chamber does not really put the accused person in a situation where he suffer from any hardships, and the principle of nebis in idem is established to bring justice to everyone, and of course it is fair for everyone already, and in all circumstances the nebis in idem principle can be applied here, and there is no provision stating that the principle of nebis in idem shall not be applied with regard to the same fact. And that if we look at the criminal procedure of Cambodia, and although the judgment of the People Revolutionary Court of Cambodia of 1979 was not the final one, and that the trial was concluded and the judgment was not subject to an appeal, Ieng Sary shall not be barred from prosecution before the ECCC, and that nebis in idem is not violated here at this court. The co-prosecutor therefore would request respectfully that the trial chamber reject the request, the submission by the defense counsel for Nuon Chea for Ieng Sary rather, concerning the nebis in idem that shall not be applied before this chamber. And the accused person has committed, as they already indicated, the defense counsel stated about the judgment of the People Revolutionary Court of 1979, indicated clearly about the deprivation of his that the trial chamber has no jurisdiction over the accused person, but we object to that observation. My colleague, Mr. Andrew Kelly, will touch upon the covenants on civil and political rights and other remaining issues. Thank you, Your Honors. The President, thank you, Mrs. Chia Liang, the International Co-Prosecutor. You may now proceed.
Thank you, Mr. President. First, Your Honours, I'm conscious of the direction that's been given by the trial chamber, first in stating in the agenda for today's hearing that you are familiar with all of the written filings that have already been filed in respect of this matter, and secondly, the direction that you gave to the Ieng Sary defence that we concentrate on first whether the People's Revolutionary Tribunal was fair in accordance with basic trial standards, and secondly, whether the pre-trial chamber's decision actually gave rise to any new arguments in respect of the ne bis in idem principle. I will be repeating very briefly some of the points made by my colleague, simply to give a logical sequence to my argument, but I will principally be concentrating on the fair trial issue in connection with the People's Revolutionary Tribunal. To the extent that arguments already made before the pre-trial chamber have been repeated and are to be further considered by the trial chamber, we expressly reserve the right that our own prior arguments should be considered, and in fact we state that in paragraph 31 of our response to the further submissions by Ieng Sary. That's our filing of the 7th of June of 2011. In essence, the position, I think, of the prosecution rests on 3 points. First of all, we say that the provisions of the Cambodian Code of Criminal Procedure dealing with ne bis in idem, dealing with double jeopardy, the res judicata provision, do not apply to this situation. Secondly, we say, and as my colleague has already stated, we say that the pre-trial chamber was correct in finding that Article 14.7 of the International Covenant on Civil and Political Rights does not apply to proceedings before the ECCC. And lastly, we say, relying on guidance provided by the provisions in the ne bis in idem parts of the statutes relating to the international courts, the Yugoslav Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone, and the ICC, we say that the ECC is required to refrain from exercising jurisdiction only when national proceedings have been conducted impartially, independently, and in accordance with the norms of due process recognised by international law, and that part of my argument will lead directly into my discussion on the fair trial issues surrounding the People's Revolutionary Tribunal, which we say was not a fair court, was not independent, and was certainly not impartial. So, the first part of my argument, very briefly. The provisions of the Cambodian Code of Criminal Procedure of 2007 simply do not apply here. Why? Well, because the principle of res judicata referred to in Article 7 and 12 of the Code, essentially barring a second prosecution for the same act, only applies to a person who's been finally acquitted. It's very, very clear when you read 7 and 12 together. Now, the pretrial chamber examined this issue in some detail. You'll find that at paragraphs 122 and 123 of their judgment, including the defence assertion that one should interpret Article 12 as applying to those finally convicted, like their client, even though that's not what the provision states at all. The pretrial chamber examined other provisions of the Cambodian Criminal Code and found that there was actually very good reason why Article 12 only refers to those finally acquitted. And one of the reasons for those, and my learned friend Mr. Carnavas has already referred to this, and I'll give one of the reasons, is because other parts of the Cambodian Criminal Code of Procedure give a convicted person, a person who's been convicted in his or her absence, to come back before the court and challenge that judgment in person. That's under Articles 365, 370 and 371. If the principle of res judicata, Article 12, applied to individuals who had been convicted, it would actually deny that individual an express right set out in the rules, in another part of the rules, to challenge the judgment against them. That can't be right. Now, the defence response to that argument is this, that double jeopardy, ne bis in idem, is only a right which the accused can invoke, and that it cannot be used to deny the accused of other beneficial rights, such as the right to challenge a judgment against that person under the Cambodian Criminal Code of Procedure. Now, the OCP position on that defence argument is very clear. We say you cannot argue in a single case that the rules say you cannot try me because you've already tried and convicted me, double jeopardy, but on the other hand, the same set of rules allow me to challenge the conviction against me in my absence and have a retrial. Now, it doesn't make any sense to me. And I think, Your Honours, it probably won't make any sense to you, that argument. You cannot argue that res judicata applies in all cases except where you don't want it to apply. The pretrial chamber was absolutely right in its determination on this issue. Article 12 does not apply to convicted individuals. So, in my respectful submission, the trial chamber must look elsewhere for guidance on this issue. Let's look very briefly now the second plank of my argument, the International Covenant on Civil and Political Rights, Article 14.7. My colleague has already addressed briefly the transnational application of the ICCPR to the ECCC, and I'm not going to repeat that part of the argument other than to reiterate that the pre-trial chamber rightly found that there is no international protection for double jeopardy under the International Covenant on Civil and Political Rights, since the extraordinary chamber in the courts of Cambodia is an internationalised court. Now, my learned friend Mr. Carnavas says, where does this concept of an internationalised court come from? Well, I'm not going to labour the point, but there are a number of decisions, including decisions by this chamber, and I'll simply cite one of them. This is a decision E39-5 of the 15th of June 2009, where this chamber notes that the extraordinary chamber in the courts of Cambodia, which were established by agreement between the royal government of Cambodia and the United Nations is a separately constituted, independent and internationalised court. Now, the pretrial chamber has also found this to be the case. There are a number of decisions, I won't labour the point, but it is a fact that both the pretrial chamber and this chamber have found this court to have a special status. And there are a number of reasons for that in those decisions, which I won't labour, but which have been examined by the chambers and which give a very solid foundation for the argument that this court has a special internationalised place within the domestic legal system of this country. So we say on that basis that the covenant does not apply to proceedings before the ECCC. Article 14.7 does not apply. Now, lastly, even if you find that the pre-trial chamber was wrong and that Article 47 does apply, we maintain our position that the substantive requirements of Article 14.7 are not met. And we refer you to paragraph 18 of our response to Yang Seri's supplementary submission. That's our response to the 17th of June of 2011, and I'm not going to repeat those arguments again here because the arguments are clearly set out. So lastly, and moving on really to the final part of my argument, looking to guidance provided at the international level in the international courts in respect of this principle of double jeopardy or non bis in idem. In essence, the Yugoslav Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone, and the International Criminal Court governing instruments all contain provisions which require them to refrain from exercising jurisdiction where an individual has been tried for the same conduct before a national court, as long as those national proceedings meet certain specific requirements. What are those requirements? Well, the ICTY, the ICTR, and the Special Court for Sierra Leone all require that in order for ne bis in idem to apply, the national proceedings must have been conducted independently and in accordance with norms of due process recognised by international law. Now, the provision of the International Criminal Court has an additional requirement which states that not only that the national proceedings must have been conducted independently and in accordance with the norms of due process recognised by international law, but also that those proceedings were conducted in a manner which in the circumstances was inconsistent with an intent to bring the person concerned to justice. Now, let us look very briefly at Article 23 of the Rome Statute. And I will read part of it out to you because I think it's important that it's on the record. And this is what it says. No person who has been tried by another court for conduct also prescribed under Articles 6, 7 or 8 shall be tried by the court with respect to the same conduct unless the proceedings in the other court, A, were for the purpose of shielding the person concerned from criminal responsibility for crimes within the jurisdiction of the court, or B, otherwise were not conducted independently or impartially in accordance with the norms of due process recognised in international law, and were conducted in a manner which in the circumstances was inconsistent with an intent to bring the person concerned to justice. Now, concentrating on Part B, the second test. Now, the defence interpret the second part of the sentence of Article 23b, and that second sentence, let me remind you, Your Honours, and were conducted in a manner which in the circumstances was inconsistent with an intent to bring the person concerned to justice. They interpret that, the defence interpret that as meaning that the proceedings were conducted in a manner to assist an individual in evading justice. And that's paragraph 37 of their appeal against the closing order of 25 October 2010, and they repeat that argument in paragraph 28 of their supplementary submission to the court of 27 May 2011. Now, I would submit to you, with all the respect that I owe the defence, that that interpretation of 23b of the Rome Statute is simply wrong. Why? Well, because Article 23a, you will recall, which I read out earlier, which deals directly with the issue of shielding a person from the jurisdiction of the court, deals with that situation. Proceedings contrived to shield an individual from responsibility. It's my submission that these two different sections cannot mean the same thing. The drafters cannot have intended for A and B to mean exactly the same thing. As the pretrial chamber points out at paragraph 141 of its judgment, the defence don't cite any case law at all for the proposition that these two sections actually mean the same thing. And at paragraph 152 of their judgment, the pretrial chamber, they state that there is nothing to suggest that the words "was inconsistent with intent to bring the person concerned to justice" requires an intent from the state prosecuting to make it more difficult to convict the accused. The last sentence of paragraph 152 of their judgment says the following: "This requirement of shielding the accused from criminal liability is already mentioned in Article 23a, and so interpreting Article 23b as also including it would make the provision redundant and therefore useless." Now, I'm not going to repeat all of the written submissions already made, but I would invite the Chamber to read paragraphs 153 to 156 of the pretrial judgment, which examines jurisprudence of the Inter-American Human Rights Court, which actually bolsters the position of the OCP, which I'm submitting to you. In conclusion, Your Honours, we submit that procedural rules at the international level establish that an internationalised tribunal, you've declared that yourselves, that this is an internationalised court, cannot exercise jurisdiction in respect of individuals that have already been tried for the same acts by national authorities unless it is established that national proceedings were not conducted independently and impartially with regard to due process of law. We agree with the pretrial chamber, and we submit to you that proceedings before the People's Revolutionary Tribunal fell far short of independence and impartiality and regard for the due process of law. Now, my final submissions to you will be a brief examination of why I say that. A cursory review of the surviving record of the People's Revolutionary Tribunal demonstrates that it was not an impartial and independent process. I would refer the court to paragraph 162 of the pretrial chamber's judgment, which contains a very useful chronology the People's Revolutionary Court, the court's activity, so it basically gives you a calendar, a diary of what happened. Now, the People's Revolutionary Tribunal was created not by law,
The President, we have been notified by the AV officer that the DVD has run out. We would like to break for a few minutes so that the new DVD can also be put in place.